Good afternoon, and thank you for joining us today. I would like to welcome you to the second part of FortneyScott's Workplace Legal Compliance webinar series entitled What to Expect from DOL. This webinar will be recorded. Today's presenters are FortneyScott attorneys David Fortney, Adriana Jones, Sarah Mugman, and Nita Beecher. I will now turn the program over to Nita to start the webinar.
Hi, everyone. We're looking forward to talking to you about what probably one of the busiest agencies in all of the government, the Department of Labor, is doing right now. So let's go to the next slide just quickly, reminding you that we are a Washington, D.C. firm. This is the center of the work that we do, dealing with workplace compliance. Just a reminder to listen to our DC Insider podcast when you get a chance. All right, well, let's jump right into what we're going to talk about today with my colleagues. We're going to do a quick overview, reminding everybody what DOL looks like. We're going to talk about something very important that we don't think others are talking about, which is the whole AI initiative, which has DOL at the center. Then, of course, we got to talk about regulations, something that everybody's been waiting for, but it's taken a while to get there. Wage and hour, OSHA and OFCCP, and finally some takeaways. Go to the next slide, please. So we are now in DOL Trump 2.0, and like other buildings, this is the picture that you can find at the Department of Labor, right, David?
Yeah, it is, Nita. Hi, everyone. So, yes, this is what the Francis Perkins building down at 200 Constitution Avenue, in fact, looks like. Some people say, did you use AI to generate that? No. Unfortunately, that's the real deal, as we say. This has become sort of widespread in DC. Many of the agency buildings are now draped with typically a picture of the president, as you see here, and the flag or other similar things. Some calling out 250 as the banner on the left. I just a personal point of observation. I mean, honestly, I was in Beijing when I saw similar banners, and I just find it jarring, having been in Washington a long time. We just never have done anything like this before, so it is something new. Maybe it says something, I don't know, but it is the way it is today. And it is certainly a reminder of the Trump administration in every sense. And it kind of frames up nicely what we're going to be talking about today, Nita.
Well, David, let's jump right in. Let's go to the next slide, please. So, David, with your background in the Department of Labor, we're going to let you kick this off and kind of talk about for us, where is DOL right now? How is it? What is its core mission and leadership? Because you've met a lot of these people, you've known them for years. So, next slide for David.
Sure. Thanks, Nita. So I know this feels like an eye exam, this chart. This is actually, as I say, torn right off the DOL's website. So that is the current organizational chart. Um, the key things and the key areas that we want to talk about. First of all, what is the purpose of the chart for everyone? One, the Labor Department has a lot of different enforcement agencies, a lot of different functions that are housed in it. You can study the chart and pick up the granular detail if you want. Number two, within our available time today, we're going to really focus on those boxes that are highlighted in yellow, the DepSec. We're going to talk about the Solicitor of Labor, the Employment and Training Administration, OSHA, Wage Hour, and OFCCP. But as you can see, those are just quite a small number among the many, many agencies and functions that the Labor Department poses. And we really put that out so you can, I think of the Labor Department and typically try to describe it's like a holding company almost, that it has a lot of, they're all sort of related to the workforce, but there are training agencies, enforcement agencies, outreach agencies, benefits agencies, various judicial administrative functions for ALJs and other review boards, because many of the statutes are set up with that component. So this is a very helpful overview, and it does indicate, as I said, it's right from DOL's current website.
Well, David, it's interesting because one of the ones right next to wage and hour is the vets, which is another area where we know that federal contractors have to comply and file their 4212s every year.
Well, that's right, Nita. And there are many additional boxes we could have highlighted that employers regularly deal with, the Bureau of International Labor Affairs, Office of Labor Management Standards, et cetera. But in the available time today, those are the top tier ones that we've scraped off to talk about. Well, let's briefly fill in some of those boxes, and maybe we can look at the next slide. Just briefly, this is the Secretary of Labor, Secretary Chavez de Remer. Interesting pick for a Republican administration. The Teamsters President Sean O'Brien, back in the period between the election and when the president was sworn in, when the cabinet offices are being determined, uh, Teamster President O'Brien jetted what was then former Congresswoman Chavez de Remer down to Mar-a-Lago, met the president, and almost immediately following that meeting, then President-elect Trump announced that she would be nominated to be the Secretary of Labor. I think it's fair to say no one in the business community, employer community, we didn't have her on our dance card. She was a one-term congresswoman from Happy Valley, Oregon. She was although Republican, she was a co-sponsor of the PRO Act and actually sent kind of a shudder through the spine of many in the employer community. We didn't quite know what to expect. I would note there's a lot of published information to the effect that the Inspector General has various investigations involving her conduct at the moment. It's premature to really comment on whether those will go anywhere or whether they will impact her long-term status. Stay tuned.
David, one thing I wanted to point out about, I actually pulled this particular quote because I think it keys up some of the things we expect and what we're seeing with the executive agencies. A golden age, Trump's golden age, fighting for the American worker, which was on the poster we saw, and make America work again. So those are kind of themes, I think, from the Trump administration.
That's right, Nita. And really, this administration has done, I think, a pretty good job for tying back to its animating principles, and we'll kind of build that out as we look at these agencies a little bit. Let me just briefly introduce two of the other very top officials. If we look at the next slide, Sarah, please. And that's both Keith Sonderling and Jonathan Berry. Keith is the deputy secretary. He was one of the boxes at the top there that we had in yellow. Why do we have him in yellow? Because de facto, he is running the day-to-day operations. Think of him as a very active chief operating officer. He very much has his hands on the controls of every agency at the Labor Department, regularly interfaces with the White House Domestic Policy Council, regularly interfaces and involved with the other labor agencies, the Labor Board, and others that aren't actually part of the Labor Department. Second ranking official, former EEOC commissioner, formerly in Trump 1.0, was at the Labor Department, ran the wage hour division for a bit of time there as the acting administrator. So he knows the Labor Department extremely well, and I think is doing, frankly, an excellent job in running the department under sometimes rather trying circumstances. His historic focus has been on AI. Not surprisingly, this administration's focus is on AI, so Keith is a perfect match there. Let me say a word about the solicitor. The solicitor is actually the third ranking official at the U.S. Department of Labor. And Jonathan Berry, formerly perhaps was best known to most people when he authored Chapter 18 in the Heritage Project 2025. That chapter forecasts much of what we have seen so far. The rescission of 11246, President Trump did that. Elimination of OFCCP, well, we're going to talk about that, not so much. And the reinstatement of the prior independent contractor rule. I think that's coming. Interestingly, just last week, Jonathan issued an internal memo in which he called out, and these are his words, the big, the bad, and the ugly. What is he referring to? He is referring to employers and targets of how the Labor Department will focus its enforcement efforts. The Labor Department is a very powerful enforcement agency with over 500 lawyers. They have a great deal of litigation autonomy. They don't rely on the Justice Department to bring their cases, generally speaking. So therefore, when the solicitor says the big, the bad, and the ugly, now I'm not quite sure what that means. I had some exchanges with him shortly after he issued that memo. I'm still not sure I fully understand it, but I've got a sense that he's talking about that anyone that isn't aligned with the administration's priorities may be viewed as either the big, the bad, or the ugly, and be subject to appropriate enforcement action by the solicitor. I think that's noteworthy.
David, I think we'll see, like we've seen in other cases, the FCC, the FTC, the EEOC going after those corporations who don't fall in line.
I think that's right. I think that's right.
Well, I think the next slide is Adriana. Adriana, so can we talk a little bit about the core mission? And welcome to the webinar, by the way.
Thank you. Good afternoon, everyone. So as we have discussed, the DOL's aligning itself with President Trump's agenda, and DOL is actually taking they are the forefront of these changes, and they're an integral part in implementing these changes. And we've already covered some of these themes, but what we're going to be covering, going through this presentation is additional, like the reorientation toward deregulation and regulatory simplification. So we're going to reduce regulatory burdens on employers. In addition to this, you're going to see that there's going to be this shift towards guidance over investigation. So you're putting it on employers to comply and streamlining these compliance processes. In addition, we're going to talk about prioritizing the future of work, so in AI and technology, and then the expansion of apprenticeships and skill-based workforce for skill-based workforce pathways. But DOL is going to be doing this with a budget that's been cut by 13%. So they have 13% less for workplace enforcement. So what does that mean? That is a significant deduction for this agency that's already stretched thin. And in total, the department received $13.7 billion. But even those, this means to them that they need to prioritize cases with the biggest worker impact footprint. So for employers, fewer resources doesn't necessarily mean less scrutiny. It's going to mean more targeted scrutiny. So that might be the answer of the big, the bad, and ugly in some cases, is the fact that they're going to be targeting on that scrutiny. So think of it like a hospital during a flu season. The fewer staff doesn't mean fewer emergencies. It just means that they're going to triage it differently. So DOL is doing the same. They're going to be doing this in a very strategic way. And when we discuss about the shifting from the active enforcement to the proactive guidance, we'll cover that later on in addition to this. But then something important that's happened is now the publishing of 20 years of enforcement agency data. And this is the DOL's open data portal. And they've aggregated 20 years of enforcement data, and it covers OSHA, MSHA, VETS 4212, and the wage and hour, and though notably not OFCCP at this time. And so the portal is intended to increase transparency for the public, and then also to provide some insight into enforcement trends, so like case types, the industries, the timeframes, and the outcomes. And so what this might mean, or what this is going to mean, is that DOL's already announced also they're going to implement AI into this tool. And by doing so, they're going to be able to identify non-compliance patterns and detect anomalies and streamline the triaging that I discussed before. So then once that's active, employers with outlier data, like the high incident rates or repeated wage issues or industry-specific risk patterns, those are going to be flagged faster. And this makes the core mission, their DOL, very much focused, very much much more efficient with the AI piece. So if we want to, this is going to be the future of enforcement, like less door-to-door investigations, but more data-to-data.
So David, Adriana just told us about how they are trying to be more efficient. So let's go to the next slide. Can you talk a little bit about the difference between the Trump administration and the Biden administration?
Sure. And I think, you think about it, every administration has, if you will, carrots and sticks. Sticks meaning, direct enforcement action. We've heard from the solicitor. I think Adriana's done a nice job of laying up the tension between somewhat reduced resources, how to prioritize the resources. So part of the decision that's being made is that there's going to be greater encouragement and inducement for voluntary compliance. That's what I call the carrot part, putting out more guidance, standing up programs that allow employers with confidence to know that they are compliant. That can include regulatory reform. We're going to talk about some of the check-in procedures that Wage Hour has stood up. for self-evaluations. This is quite different than the approach that the prior, immediately past administration took in the Biden administration, which was predominantly sticks. They viewed carrots as being I often heard it pejoratively referred to as a get out of jail free card. I never thought that that was a fair characterization, but nonetheless, that is what the critics of it do think. So I think that, compliance assistance is going to be a big part of this administration. And I think the solicitor's equation, now we begin to understand the big, the bad, the beautiful. That's who's going to get the stick. But the carrot is where they're putting a lot of energy, certainly on the first beginning year, 18 months of this administration.
David, one last thought as we get ready to go and talk a little more detail about AI is that it reminds me is that they are pushing out enforcement in a way, pushing out enforcement compliance on employers to handle rather than internally.
I think that's right, Nita. I really do. We'll see how that works.
All right. Well, we've hinted around about AI, and so let's go to the next slide. Sarah, kick us off. Thank you for being in the webinar with us. It's nice to have you here.
Happy to be here.
Let's talk about AI and what the Department of Labor is doing on this very important subject.
Of course. Thank you, Nita. And next slide, please, Sarah. So really what I'm here to, I'll let's first look at how the department is approaching artificial intelligence. And it's actually rather similar to how the institution has approached major workforce shifts throughout history. And the department has tended to respond with really a common strategy, which is preparing the workforce and employers to really adapt before shaping those compliance mechanisms or engaging in enforcement efforts. And we can really see this pattern repeated across the past several decades. So you've got the 1950s, there's rapid advances in factory automation, and that's displacing large numbers of workers. And so the department then focused on large-scale training and reskilling initiatives that helped workers kind of move into these new types of jobs that were created by technological change. Then you've got the 70s, where you've got manufacturing processes growing more complex. That's increasing workers' exposure to safety and health risks. So the department responded by really investing in education and training of workers, employers, and really all stakeholders to kind of first mitigate that risk before gearing up any sort of enforcement mechanism. And I'll just briefly mention here the 90s as well, because you've got the Department of Labor really modernizing its public-facing systems to integrate these kind of new digital tools with the internet and all those things to existing really employment and workforce programs so that workers and employers are really engaging with those tools, which we're seeing with AI as well. So under the current administration, the department is really treating AI as one of these long-term structural shifts. So as we're going to discuss further, the department is really currently focused on establishing foundational principles for workers and employers to embrace technological change responsibly. They're beginning to study AI's really workforce impacts. We've got the department gearing up to identify which industries and jobs really require education and training the most, all while maintaining a flexibility both for itself and the workforce as a whole to really adapt as AI's impacts become clearer through evidence or data. And I would say the key takeaway for employers here is that there's likely to be an evolution of the department's guidance over time rather than some sort of singular regulatory event, because the department's position really promotes AI innovation over restriction. It emphasizes workforce readiness for AI, and it's also focusing on really guidance-oriented initiatives.
Sarah, can I just add, and maybe we can go to the next slide while doing that, but looking at this, you think about those timelines that were laid out there. As widespread industrialization to ensure equal opportunity, the Civil Rights Act in the 60s, with the health and safety challenges, we have the Occupational Safety and Health Act. And it remains to be seen, as you point out. AI has not generated any new federal statutes or requirements. We're trying to shoehorn it into that existing statutory framework of protections that exist. It remains to be seen whether that's adequate.
And I think that's right. I think, we've got this AI action plan, right, that was released by the White House in July of 2025. And that kind of sets this framework for that the department has been following. And that the AI action plan really serves as this administration's kind of strategic blueprint for the US to achieve global dominance in that AI space. So, under the AI action plan, the Department of Labor was really assigned several responsibilities, and it has since begun taking actions that are aligning with directives from the White House. So, the AI action plan really tasked the department with preparing the workforce for AI driven change. And as an initial step, which we're soon going to discuss, the department has identified these foundational skills that workers will need in an AI-enabled economy, and it's encouraging the development of those skills across all industries. So the department has titled this guidance the AI Literacy Framework, and it's intended for all stakeholders. This is for workers, employers, educators, training providers, and state and local agencies as well. Under the AI Action Plan, the department was also directed to analyze AI's impact on the labor market. And because the AI Action Plan promotes deregulation related to AI, and because the department is really focused on the carrot rather than the stick for enforcement, as David has discussed, we can anticipate that this labor market analysis is likely going to influence really gradual policy developments and guidance over kind of immediate formal rulemaking and enforcement efforts. Lastly, we'll also discuss this shortly, but the department has been charged with supporting and developing education and training programs. I'll note quickly here that the AI Action Plan names the Department of Labor first as the lead on these educational program developments, rather than the Department of Education, which establishes that this administration really believes that the Labor Department is playing an integral part in fulfilling the AI Action Plan. So with all that in mind, I guess, David, I'll hand it over to you to kind of give us a little bit more detail about the AI literacy framework released last month.
Sure, I'd be happy to. And as we go to the next slide, let me just note, I think Sarah's done a very nice job of laying out the administration's view, deregulatory, we're putting out frameworks and so forth. I want to contrast that because not all the states are on board. And indeed, and this is a fascinating both small p and large p political development, we have the state of Florida, not California, the state of Florida leading the AI Bill of Rights that Governor DeSantis has been championing, and the administration now actively opposing states enacting any restrictions on this. The administration believes that this should be, if you will, federal common law. They don't quite have that preemption argument. They tried to enact that in the big, beautiful bill. They couldn't get it. But they've tried to dissuade states in whatever manner they can. Florida's on the tip of the spear, trying to go a very different direction. Interestingly, Louisiana and some of the other traditional deep red states are viewing that they have state obligations to protect their citizens. They're not willing to defer to this framework that the administration wants to put out as being sufficient. That's a very interesting issue. And for employers, it could whipsaw us and be caught in between, betwixt and between. But in any event, at this point, the states haven't gotten there. What we do have, as Sarah indicated, this literacy framework. Now, this is where I think the administration has done a really nice job of starting to click down. And the reason we want to spend a little bit of time on this, because we don't think that most employers, outside those perhaps in the tech space, are really adequately being informed and tracking and paying attention to this. We think this is, my personal view is probably this is the most significant development that the Labor Department is working on, is the implementation of AI in the workforce. As seen here, they've laid out very detailed framework for implementing AI, that you have to understand the principles, explore the proper uses, direct AI effectively, evaluate the outputs, and use AI responsibly. Notice these are at best guidelines or general framework for guiding. This isn't mandatory, but it does represent, I think most people would agree, a sound best practices. Just a little further, next slide and they've actually drilled down from the framework. We won't go through each one of these. It's available to those that are interested, but the actual effective delivery of how these principles are to be implemented. Again, these are applicable, I want to stress this, to all employers, All employers are using AI across the board. We believe, and we are actively counseling and advising a number of employers on how to think about this, how to implement it. There are lots of issues, both in terms of legal and practical considerations, and implementing. But I think the Labor Department, this is a talk about leading by example and putting out there clear standards. I think the Labor Department, I think Sonderling, Deputy Secretary Sonderling deserves a lot of credit for this. Taylor Stockton, who's their chief AI officer, and if I can just say, we did have him on one of our podcasts that you threw out there, Nita, at the beginning. We've had Taylor on to talk about this. There's a lot there for employers in this. This is a very rich, and the Labor Department can be a very good partner to help employers in responsibly implementing AI.
So Sarah, what else is the Labor Department doing to keep everybody in the loop?
Of course. So I think, as I mentioned earlier, we've got the AI action plan tasking the Labor Department with really gathering and analyzing data to determine AI's effects on the labor market.
Sarah,
And
let's go with the next slide before you get too far down the road here.
oh, my apologies, I forgot.
No, you're fine.
Anyway, so specifically, the AI Action Plan really assigned the development and launch of an AI workforce research hub, which is not yet operational, but it's anticipated, of course, in the foreseeable future. And in its press release of the open data portal that Adriana mentioned earlier, the department really mentioned its intent to expand data sets and ensure AI integration in 2026. So it's possible that this tool really may incorporate that research hub. But the hub really, the goals within the laid out in the AI action plan for the hub are going to be, first, really, it's intended to provide a continuous analysis of AI's effects on the workforce. And that's measuring job creation, displacement, effects on wages. And that means that this tool will allow the department to monitor how AI is reshaping labor markets over time, rather than just relying on one-off studies or engaging in kind of reactive policymaking. We've also got the hub expected to identify workforce risks and forecast kind of potential future changes. So after the department begins identifying certain roles or industries or trends that might be higher risk, it can then further scrutinize those data sets or issue further targeted guidance. And really, the last goal of this hub is going to be to generate actionable insights, and particularly as it informs workplace and educational policy. So with those insights generated, it could influence how training programs are structured, how workforce development funding is allocated, and really how regulators will evaluate employers' preparedness for this AI-driven change. And I think the key takeaway here is that we're anticipating entering soon into an analytical phase, with the department really providing ongoing data analysis and forecasting. And that may shape how employers can assess the workforce impacts. They can evaluate the skill needs within their workforces and also demonstrate meaningful AI deployment.
Well, that's really important what you're talking about. And Adriana, I think because the Department of Labor, let's go to the next slide, talks about apprenticeship, this ties into what they've done for years, but it's different at the same time.
Right. This is a proactive, very important proactive push that they have been focusing on. And in the past, we've associated apprenticeships or registered apprenticeships with the construction, but that is no longer the case here. I mean, this is an very huge expansion where the administration issued multiple executive orders, at least 4 of them in 2025, explicitly directing federal agencies to expand their apprenticeship systems and then use registered apprenticeships to support the economic and industrial policy that the administration is pushing. And so there they focused on, I think the EO had the AI, artificial intelligence education for American youth. They had Restoring America's Maritime, so very focusing on shipbuilding and maritime trades. They had Reinvigorating the nuclear industrial base in another EO, and so they're calling for directing agencies to use apprenticeships to rebuild those specialized technical pipelines, and then in addition to others that we're seeing, because this DOL is very busy, very much engaged in expanding this, and then also with the goal of meeting this 1 million apprentices for this administration, which was in EO 14278. So this rapid growth has to be built around these national guideline standards, which the Department of Labor continues to issue, and both the national guideline standards and national program standards, and they're issuing these in an accelerated pace to assist these industries to build those apprenticeship and to add to their training expansion. And so with this, the volume and the pace of these new bulletins indicate a rapid scaling of the registered apprenticeship and then into the emerging industries previously underrepresented in the system or in the apprenticeship piece. So in addition to that, we're also seeing a scale back of regulatory burdens where there were EEO requirements and there was a July 2025 NPRM or Notice of Proposed Rulemaking, which the comments ended in September. Well, we haven't seen anything yet, but that would be rolling back several long-standing regulatory requirements, including the affirmative action plan requirements for those specific programs. And with that, under that proposal, we'll see sponsors would instead rely on existing frameworks and non-discrimination laws rather than the separate apprenticeship-specific EEO structure. So again, they're trying to build it so that this avenue is easier to approach for employers and easier to use so they can build out in these industries. And really what it came down to is that workforce strategy alignment, which is the America's Talent Strategy. And this was released jointly by the Departments of Labor, Commerce, and Education in August of 2025. And so that really became the umbrella framework that is pulling all of this apprenticeship and the workforce and the modernization efforts together. And it's essentially the national workforce blueprint to unify those programs and to make it so that it's not the same across the board. It's not siloed anymore, which they found that it emphasizes it removes the current patchwork and instead streamlines it. So that way, again, making it so that the goal of 1 million active apprentices. So this area is going to expand. It's going to be even more of a focus for the DOL agency and for employers to focus on too, as we're seeing a lot of programs allowed or through the government that's getting put, I guess the money that is being funded through to support these apprenticeship programs. And within the last 2 weeks, I think it was 146 million that was funded, in addition to another two other funding opportunities for 86 million or in the $80 million range. So we're seeing this push for these registered apprenticeships. It's going to be big.
Well, I think one of the interesting things is a push away from colleges and universities and to community college and other technical areas. Well, we've talked a lot about AI. It's time to switch gears to regulatory, or I guess let's go to the next slide. I guess right now we're really talking about deregulatory in a lot of ways. And Adriana, I hate to say this, but you're up first to talk a little bit about the busiest of all the sub-agencies in the Department of Labor, which is wage and hour. So let's see the next slide. Yeah, there we go.
So the wage and hour division is led by Administrator Andrew Rogers. And as many of you know, and as Nita had stated, the Wage and Hour Division is a very active workforce agency right now. We continue to see it take the lead on issues that are affecting day-to-day operations for employers of all sizes. So under its current direction, Wage and Hour is really focused on, again, streamlining these regulations to make compliance clearer for employers. They're improving coordination with other federal agencies, and then they're expanding these opportunities, which we're going to discuss later, for voluntary compliance and really pushing that so employers can get things right before the problems arise. And it's an area where the pace of activity is high and the emphasis on practical, workable compliance is stronger than ever. And David, I know you wanted to perhaps
I just wanted to give a shout out. Yeah, Administrator Rogers, Andy Rogers, very solid, very deeply experienced, substantively qualified person to lead Wage Hour. He previously did a stint in Wage Hour in Trump 1.0. He was counsel to then EEOC Commissioner Lucas. He then became the acting general counsel at the EEOC and then moved over to where he was confirmed by the U.S. Senate after being appointed by President Trump to head the wage hour division. So he's someone who he understands enforcement, he understands wage hour, and he understands, if you will, both carrots and sticks, and is extremely well qualified. And I'm really very pleased to see him in this role.
Well, I think that's great. So let's go to the next slide. And Sarah, one of the items we talked about, which the Solicitor of Labor had pointed out in the Chapter 18 of the 2025 Project 2025, was to change the IC rules. So can you talk us through? It just was announced on Friday of this past week. It was published on Friday. I know that.
Yes. So last Friday, the Department of Labor's new proposed independent contractor rule was published. It's important to note, of course, if you intend to comment, that comment period is scheduled to close on April 28th. But the proposed rule really just largely reinstates, with slight modifications, the 5-factor independent contractor rule from 2021, which, again, as we've been saying, streamlined. It is a streamlined economic reality test that is focused on 2 core factors. So that first factor for consideration is going to be the nature and the degree of control over work. And that's who decides, how, when, where work's performed. And then you've got the second important factor, which is the individual's opportunity for profit or loss. And that's really focusing on whether the worker is meaningfully influencing earnings because of their built up managerial skill and business judgment, rather than just working more hours. So, of course, just to make sure we've rounded it out, we've got the other 3 factors. That's going to be the skill required for that work, the permanence of that working relationship, and also whether the work is part of an integrated unit of production. Again, these 2 core ones, of course, are kind of the heart of this proposed rule. So the proposed modifications that have been added to this rule compared to the 2021 rule are really just clarifications about economic dependence, which is really what lies at the heart of independent contractor analysis. And so the first I would say the first part that the proposed rule distinguishes for economic dependence is employees typically hinge on the reliance on the employer for access to work, whereas independent business owners are going out and actively pursuing opportunities in a broad work marketplace. So this framing really reinforces that the question is not simply how a worker is paid, but really whether the worker is functioning as an independent business. Same thing with the second clarification. That's addressing that economic dependence is not about the amount or the source of a worker's income, but really what is the worker's access to opportunities. And that means that independent contractors are really those that have the freedom and the ability to seek additional or alternative work in a way that resembles operating an independent enterprise. So while this proposed rule is, of course, subject to change after the comment period, the direction is clear. And that's that the department is really signaling a return to a more structured and predictable analysis compared to the broader multi-factor approaches that we've seen in recent years. And so ultimately, the proposed rule is intended to sharpen that overarching economic dependence inquiry while providing employers with clearer compliance guidance. And with that guidance, employers can then meaningfully assess, their classification frameworks and try to mitigate any compliance risk.
What's really interesting about this, and then we'll go on, but what's interesting is this is one of the first regulations after Loper Bright occurred, and there's a lot of litigation around independent contractors, and the courts may not agree with what the Department of Labor has said is an independent contractor, and they don't have to. They get to make their own decisions. And with that, Adriana, what are some of the other regulations that we need to think about? Going to the next slide.
Yes, so we're going to cover joint employment. Just a quick rewind. In Trump 1.0, the Department of Labor tried to narrow joint employer liability by focusing on situations where a business actually exercised control versus and not just had the theoretical ability to do so. So then, but a federal court in the Southern District of New York vacated it, and then the Biden administration rescinded the rule without putting anything in its place. So that brings us to where we are today, which is essentially back to the pre-2020 case law driven standard. And under that framework, joint employment can be found based on direct or indirect control and the worker's economic dependence. So we have these patchwork law based on different courts. Now, Wage and Hour has signaled that a new proposed rule will be coming, but we'll see what ultimately comes out on that proposal. So at the same time, though, the NLRB is moving on its own joint employer track. The board issued a final rule scheduled to be published on February 27th, and it was. That wipes out the vacated 2023 rule and then reinstates the 2020 standard. And what this does is, under that standard, there are two entities that are joint employers only if one actually exercises substantial, direct, and immediate control over at least one essential term or condition of employment. So depending on which law is being applied, FLSA versus NLRA, you may see different definitions in play here. But that, again, is based on what Wage and Hour will bring out and perhaps streamline it. And I know I've said streamline a lot during out this this presentation, and that seems to be my favorite word for this presentation. But finally, a quick note on the federal contractor minimum wage rule. So the Biden era executive order 14026, that is gone. We knew that it was rescinded. But what was kind of confusing is the fact that Obama executive order 13658 still remained. And so recently, the Wage and Hour provided some additional guidance that says, yes, the Obama era rule EO still applies, but it's only to unmodified contracts issued between 2015 and 2022. So for most contractors, this practical landscape has shifted again, and it's not going to apply. And so with that, David, I'm going to turn to you for Project Firewall in the next
Sure.
slide.
Happy to do so. So this is a new initiative. A lot of the things we've talked about heretofore are the pendulum swing between, the prior administration, the current administration. Project Firewall is a new initiative. It focuses on whether H-1B visas were improperly used by employers in the past. It's looking backwards to see whether H-1B visas were, if you will, overused or misused to unfairly and potentially unlawfully deprive American workers of their opportunities. The Labor Department is the lead on this, but it also is in close coordination both with the Equal Employment Opportunity Commission and the U.S. Customs and Immigration Services at THS. The focus is on auditing prior labor condition applications, which included certifications. The secretary, they've developed a new process. So Andrew Rogers, Wage Hour actually has jurisdiction over this too. The department itself can certify that they have reasonable cause, and that can result in an investigation being opened. The exposure for employers include back wages, CMP, civil money penalties, and removal or debarment from the program. It was publicly reported that they had over 200 investigations opened by early December. Our sources tell us that this number has grown substantially. We're involved in several of these. They are quite far-reaching potentially and difficult. So it's something that those that have been, if you've used H-1 visas in the past, you will require that one of the application processes was a certification as to the then existing labor market standards that made you eligible. That is largely what these investigations hone in on, is whether your market assessment and certification were accurate. Stay tuned. I think we'll be hearing more public results about this, but I want to raise this for general awareness at this point.
David, we were able to talk about this on our last webinar about the EEOC, because EEOC is a major player in this as well. They are investigating, as we have talked about. Chair Lucas is very focused on national origin discrimination against American workers, and our favorite DOL False Claims Act also could come into play here as well.
Exactly. So, I mean, this is something I think, once again, I don't think a lot of people are paying attention to this. I think we're going to see some results, and I think people will be more attentive. But you heard it here first. Project Firewall.
So, Sarah, we've talked already about voluntary compliance, but how has Wage and Hour actually been dealing with voluntary compliance for employers?
Yes, returning, of course, to the department's carrot approach to compliance. I'll just briefly touch on really two programs. We've got the renewed use of opinion letters, and we also have the return of the Wage and Hour Division's PAID, or Payroll Audit Independent Determination Program, the PAID program. So first, we've got the Wage and Hour Division resuming its issuance of opinion letters last year, and 6 more were just released earlier this year. They're each addressing, at least with respect to the Wage and Hour Division, they're each addressing specific scenarios that arise under the Fair Labor Standards Act and the Family Medical Leave Act. And these letters are intended to expand the department's guidance by really providing their official interpretation of workplace legal requirements. And any stakeholder can request these opinion letters, and that includes workers, employers, lawyers, HR folks, union reps, whomever. And not just the Wage and Hour Division, but also we've got OSHA, you've got employee benefits, you've got vets, and you've got the mine safety and health admin kind of being all involved in this program. So while these opinion letters are not necessarily legally binding, of course, employers that reasonably rely on them may be able to use them as a good faith defense to potential liability. Then touching on the PAID program that was revived by the Wage and Hour Division, it's a voluntary compliance program that is allowing employers to identify and correct potential FLSA and FMLA violations. And this process starts with the employer conducting a self-audit. And if potential violations are identified, the employer then self-reports them to the Wage and Hour Division, which then the Wage and Hour Division will oversee any payment of back wages to employees. And so for employers, the benefits here can include avoiding, of course, litigation costs or securing a release from federal liability for the specific violations resolved. But there's one important caveat, of course. Participation in the PAID program may address federal exposure, but it's not eliminating risk under state wage and hour laws or litigation. So those decisions that employers make about using the program should, of course, kind of be evaluated through a multi-jurisdictional lens so that it's not just focused or considered a complete compliance fix.
You know, what's interesting is I remember this was in Trump 1.0, and I remember, and David, I defer to you all, but it seems to me that people didn't use it as much as we thought they would at the time.
That's right, Nita. And I think part of it wasn't perhaps lack of familiarity with it, but this point about potentially triggering yourself to state law claims, that's one that I just would underscore. Sarah referenced that. That needs to be carefully considered. But if you can do it without putting yourself in jeopardy under state law, under the FLSA, it is potentially a very powerful legal defense and deprives individuals of their private cause of action. So anyhow, it's worth looking at closely.
Well, and David, with that, I think we want you to talk a little bit about one of your favorite subjects, child labor enforcement, that Wage and Hour has been very focused on.
Sure, I'm happy. I'll kick off this. So they of course do have a lot of other priorities. Wage Hour is a big operation. Child labor settlements. They had 3 significant settlements reported out during calendar year 25 and year to date in 26, 3. Those were 6-figure settlements. That isn't the frequency or necessarily even the size of some of the settlements we saw coming out of the Biden administration. But so the question is, was child labor still being enforced? And I believe the answer is yes. This was a point certainly of the confirmation hearings for Administrator Rogers and other Labor Department officials. They all reaffirmed that they would maintain vigilance and monitoring because there is no private cause of action for child labor violations. Every indication is that they have continued to do so. What you hear from the Labor Department officials, and this is interesting, is they continue to look using many of the same techniques that were being followed before, but they're not finding the same violations that were there, say, 2 years ago. What has happened? One theory is that with the border being very tightly shut down, that the prior circumstances, which often did involve workers who were not eligible to work, who some of whom were underage, holding those jobs. There simply aren't that number of underage ineligible workers being found in the workplaces. It's not completely there, and I don't know if that's the full explanation, but that's at least some of what we've seen. Continues to be a big focus by employers in their compliance programs, and it should be in supply chain integrity, et cetera. So I think that child labor, and there continues to be some congressional interest outside the scope of what we're talking about today, but there are lots of bills pending to actually increase the penalties and making compliance even more important. So I think it's a combination of factors. Child labor continues to be focused on. I think employers have gotten better in policing themselves. And I think that some of the sources of underage workers has changed significantly from what we saw several years ago.
So Adriana, you are a queen of prevailing wage. Tell us what's going on there.
I've certainly become one very recently. No, I feel like over probably the past 5 or 6 years, there have been huge opportunities for employers to take part and to participate in funding programs and in loan programs and in grant programs. And we have a lot of clients who come across the board. Some people who have never heard of prevailing wage. What is prevailing wage? What is and in this case, to be Davis-Bacon Act or Service Contract Act, which is covered under the prevailing wage. But then in addition to that, you have the Inflation Reduction Act, which then puts forward the PWA or the prevailing wage apprenticeship. So there are all these different specific requirements that are being that are incorporated into these funding avenues, and a lot of companies are finding that, okay, well, with this comes these prevailing wage obligations, and with the focus of infrastructure being especially in the focus of this administration. We are seeing that prevailing wage is becoming a very hot topic and a very hot focus for a lot of employers who are seeking that guidance to ensure compliance. In addition to that, so the guidance for employers, there's the field assistant bulletins. We're seeing that wage and hour is very much focused on ensuring with because of the paid and the opinion letters and kind of enforcing that compliance on your own. They're releasing a lot more of the compliance assistant toolkits. They just recently updated those, so I encourage everyone to review those because it was across the board, pretty much every topic you can covered under wage and hour. They have updated or reviewed their toolkits. They have webinars. They had a recent paid webinar. It was very informative. And then, like I said, in addition to the FABs or the field assistant bulletins. So wage and hour is very active in this piece and ensuring that they're keeping compliance or ensuring that they're communicating with employers to be up to date with compliance.
Well, I'm giving to myself the next slide about something we used to spend all of our time on these webinars, which is our friends at OFCCP. As we know, OFCCP no longer has 11246, and it was scheduled by the Trump administration to be eliminated in this budget. That did not happen. They got over $100 million for this particular fiscal year of 2026. They still only have 503 and VEVRA enforcement. They still have those as statutory requirements. And as we know, the OFCCP had recommended some major changes to Section 503, along with minor changes to VEVRA regs and the elimination of the 11246 regs. Where they are with those proposals, we don't know. Many people were very objected to the changes, especially eliminating collecting disability data from applicants and employees. But as of today, we have heard that there's going to be a major reorganization. that most of the employees are being reassigned. A lot of them were reassigned after their layoff was stopped by a court. All that's left is Swarm, which is Southwest and Rocky Mountain region, and the DC national office. But they are consolidating into basically, they're going to have the Division of Policy and Program Development, which is merging the regulation, outreach, legislative and policy groups, and the help desk. And then they'll have the branch of field operations, which is going to be part of the Division of Program Operations. What all of that means, we don't know, has not been publicly announced. It's only, we've heard it in the drumbeat of Washington sources, and we will have to see where that goes. There has been the current director, Ashley, has not spoken at all and has turned down opportunities to speak. So we're just going to have to wait and see. And with that, I think it's time unless David, you wanted to make any other comments about our friends at OFCCP.
No, I don't think so. They're like the phoenix rising from the ashes. The administration tried to put them out, and here they are with $100 million budget and very little
Wow.
program responsibility. So we'll see how that works out.
Well, guys, we're getting close to the end here. So Adriana, if you just touch OSHA quickly for us.
Yes, I just wanted to take just a minute to look at what's happening under OSHA and under the Assistant Secretary David Keeling. Really just they're taking significant efforts to, again, reduce the administrative burden. So they've withdrawn the heat standard. They're taking steps to just really taking a hard look at the forms, reporting processes, and any paperwork heavy requirements to figure out what can be simplified and modernized. But then something I wanted to note specifically is that OSHA is also taking the non-traditional approach to targeting industries. Again, we've affiliated OSHA very much with the construction industry, but this time they're taking data and they're looking at data to see, okay, based on what's been reported for illnesses and injuries, what are we, which industry should we be focusing on, whether it's warehouses or manufacturing or healthcare and other high-risk environments, not just construction. So this might be picking up too. It's something that employers should be aware of.
Also,
So
I just
David,
would
you want to
note,
close? I'm sorry, go ahead.
Assistant Secretary Keeling, incredibly qualified and experienced, comes into this role after being the Global Vice President of Health and Safety for UPS. So he's someone who really is a subject matter expert, and we're lucky to have him.
David, you want to close us out on wage and on actually DOL here before we do takeaways?
Yeah, sure. I'll do a couple things quickly. Just on the ALJ issues, you mentioned Jarchezi, the constitutionality. There is a potentially open question as to whether in the Labor Department ALJs are sprinkled throughout many of the enforcement programs, both in the wage hour division, under the OSH Act, a number of statutes and programs that are administered by the Labor Department. It seems to me that anyone facing an enforcement action should include appropriately preserve the defense that the whole ALJ process itself may be unconstitutional. Interestingly, that's a question that will ultimately be adjudicated by an Article III court, not the ALJ, him or herself. But we do think it's a reminder, prudent to at least preserve that issue for future litigation. Second, we are tracking the OSHA itself, whether the OSH Act itself is constitutional, is currently being litigated. I don't think there's a high likelihood of that occurring, but nonetheless, I raise that for your awareness. And perhaps if you're facing that type of enforcement action, that's also a defense worth looking at. The federal contractor certification regarding illegal DEI, that had been enjoined for a number of months. The Fourth Circuit has just lifted that, and we're starting to see, if you will, the spigot being turned back on. Even though there hasn't been an amendment to the FAR regulations, we are starting to see the federal contractors once again being asked to certify in some manner that they do not have illegal DEI. Stay tuned. There definitely is going to be a lot more development on that in the next 90, 120-day window.
So it's time for our takeaways. Let's do one last slide here. So Adriana, you want to kick us off?
Sure. As Nina has proclaimed me the queen of prevailing wage, I'd feel like I need to definitely mention something about that. But with this infrastructure focus on this administration, there are going to be a lot of opportunities for funding, and especially with the one big beautiful bill, it is incredibly important for employers to be aware of the prevailing wage obligations. And we are very much very active in that space at this time too.
Sarah?
Sure. I think for me, my takeaway is going to be that the Department of Labor's strategy right now is really more, I would say, evolutionary rather than revolutionary, because it's still operating and enforcing the same statutes, but it's really modernizing how it understands and evaluates workplaces. So the compliance question is kind of shifting really to, have we reacted to these new rules or statutes sufficiently to really, can we show reasonable evidence-based adaptation as the workplace evolves?
And Mr. Fortney, you want to close us out?
Sure. I am completely fascinated with the Solicitor Barry's reference to the big, the bad, and the ugly. I am hoping that none of our clients fall into that category, or we don't have to tangle over that. But I think it is potentially instructive, and it does represent, although it's a bit of a cute phrase, but I think it does represent a substantive how enforcement resources will be prioritized in the Labor Department, the Trump Labor Department, under DepSec Sonderling and Solicitor Barry. So stay tuned, because I think there's a lot of bite coming up to the bark.